Hello, everyone, and welcome to this month's webinar, Ask the Attorneys Wage and Hour Changes and Trends webinar session. The specially formatted free webinar is available exclusively for our customers enrolled in our subscription services. I'm Stephanie Balicki, the subscriptions program lead for Personnel Concepts, and I'm joined by my co-moderator, Leon Frierson, who serves as our senior regulatory researcher.
Yes, hello and good afternoon to all of our attendees. A slate of new wage and hour updates in 2022 has established new rights for employees and obligations for employers. Grasping employer obligations in their entirety and properly addressing wage and hour changes through workplace policy is best served with the assistance of experienced legal counsel, which we have here today. So to answer the call, Personnel Concepts has reimagined today's webinar format, allocating the bulk of the 1-hour webinar to a live Q&A session with our panel of expert wage and hour law attorneys.
That's right. So today's agenda will consist of an introduction of each of our attorney guest panelists. At that time, they will provide us with an overview of the most impactful wage and hour laws updates they have observed in 2022 and that employers can expect in 2023. Next, our guest panelists will accept questions and answer them live, providing our beloved Personnel Concepts customers with the invaluable experience of engaging with knowledgeable attorneys on the most critical wage and hour updates affecting employers in 2022 and beyond. Before we leave, we'll provide some key takeaways from today's session, and throughout, we'll be engaging the audience with poll questions.
Yes, and speaking of engagement, let's get started with our first poll. I'll go ahead and pull that up here. And today's webinar is heavily dependent on audience participation. To make the best use of our time, we're in search of timely and meaningful wage and hour law questions to present to our panel of experts. So to ensure that we are prepared to fulfill today's wage or hour with helpful content, we need to know the following. Do you have any questions prepared for today's wage and hour Q&A session? And we want you to choose all that apply in this instance. Is it yes, you submitted a question during the registration process? We do have those on hand, so we'll answer as many as we can. Yes, you'll submit a GoToWebinar question in the GoToWebinar chat feature. Is it yes, you'd like to join the broadcast and ask your question live? We do have that opportunity for you if you raise your hand. No, you don't have a question, but you may have one based on the presentation, or is it no, you don't need any complimentary wage and hour law advice? So I'll give everyone just a moment here to answer that question that we have for you all, and it's much appreciated. Looks like a good amount of you have go ahead and responded, and I'm going to keep our response time short just because we want to get as many questions as we can for the actual session. So I'll close that out now. As you can see, most of you are saying no, you don't have any, but you may have a question based on the presentation. So we will be starting off with some basic information before we hop into the Q&A session. So that should give you some time to think of those questions.
Yeah, that's right. And as your Q&A session moderator, I'll be directing your submitted questions to the guest panelists based on their area of expertise. Keep in mind your question may be slightly modified to ensure the best outcome for the session. On some topics, you may hear from multiple speakers, allowing us to give you a well-rounded presentation experience. The purpose of this webinar is to provide accurate and authoritative information on the subject matters being discussed. It does not constitute legal advice. The applicability of the tips and laws discussed today may depend on your state, type of business, and number of employees. We recommend working directly with legal counsel and your human resources professionals on specific matters pertaining to your business. Personnel Concepts, our webinar hosts, and our guest panelists are not liable for any errors, omissions, or changes in law or advice that leads to unfavorable outcomes.
Yes, and on today's webinar, we're hosting 3 special guest attorney panelists to deliver guidance on the topic and answer questions in today's Q&A session. All 3 have previously been featured as guest speakers in our webinars. And first, I'd like to welcome back attorney Jeffrey Fuji, who is a graduate from Vermont Law School with a dual master's degree and JD, and serves as in-house legal counsel to a diverse group of corporate clients. Jeff provides counsel to his business clients on matters including labor disputes, employment negotiations, anti-discrimination, workplace policies, equity agreements, non-disclosure agreements, and general consultation. Today, Jeff will discuss the difference between exempt and non-exempt employees, very important when it comes to wage and hour, as well as provide an overview of wage and hour changes and trends in 2020 year.
Thanks for having me, Leon and Stephanie. Let's begin by addressing the overarching source of wage and hour law, which is the Federal Fair Labor Standards Act. The FLSA establishes the federal minimum wage and overtime pay rates. Supplementing the FLSA, states will also have more stringent laws in place often regarding such topics as how overtime is calculated, how tips are credited, and what defines employees versus independent contractors. That's a hotly debated subject now that we're entrenched deeply in the gig workforce economy following the COVID-19 pandemic. An employer-employee relationship is always required under the FLSA for the law to apply. For example, certain types of individuals such as trainees, interns, externs, apprentices, and graduate students may not be considered employees under the FLSA. However, it's important to remember that it's not the title, but the nature of the relationship that determines whether it is truly an employment relationship or an independent contractor relationship. And that's a very fact-specific inquiry, and we'll probably be speaking about that a little bit more when we get to the question section, we anticipate. On October 13th, 2022, moving on to another topic, the U.S. Department of Labor published a proposed rule on determining employee versus independent contractor classification. This is now again looking at the federal law coming down. This proposed rule rescinds the previous 2021 rule on the topic. According to the DOL, the proposed independent contractor rule would be more consistent with judicial precedents set across the country and the FLSA. The proposed rule focuses on an independent contractor's economic independence client rather than the amount of income they've earned or whether they have other streams of income or not. Alternatively, employers are employees, people who are actually considered to be employees under the FLSA, are those individuals who are economically dependent on their employers. The proposed rule also sets a 6-factor test up for determining economic dependence versus economic independence. And this involves an opportunity for profit or loss, a worker's investment, the degree of permanence in the work relationship, the nature and degree of control exhibited by the employer, whether the work is integral to the employer's operations, and the skills and the initiative that are involved for the particular individual who may be an employee or a contractor. In the past year, the DOL has undertaken other wage and hour rulemaking as well. Under new rules effective at the end of 2021, employers are restricted from taking what's called a tip credit when the employer performs a substantial amount of non-tipped work for the employer. And when we say substantial, over 20% of that employee's work. As of January 2022, minimum wage was increased for any workers performing work on federal contracts to $15 per hour. And this affects businesses across the board with any government contracts. Here are some other trends that are predicted to continue in 2022 and then beyond. We expect to see increased federal enforcement of wage and hour issues due to many new hires at federal agencies, and we're midway through an administration that's been hiring and staffing federal agencies due to the government, the politics, and the newness of the administration. So we can expect more workers at those places. Misclassification challenges of individuals working for employers will force businesses to take a deep look at their workforce structures internally. The great remote work migration will lead to litigation over what time should be paid and what expenses should be paid. For example, we're talking about things like Wi-Fi in the homes, software subscriptions, and hardware upgrades like printers and perhaps even phones that might be paid for by the employer when employees are working remote. And I will be prepared today to answer your questions that come up later on in our presentation with Personnel Concepts regarding these topics and any other wage and hour related topics that are of concern to you.
All right, thanks so much, Jeffrey. And here to address PPP loan forgiveness and tracking wage and hours for remote workers, we have attorney Christopher Ray. Christopher is barred in the states of Massachusetts and New Hampshire. He has served on both the employer and employee side of litigation matters, including litigation before the EEOC. He also provides regulatory compliance guidance for businesses in high-risk verticals such as cryptocurrency and the legal adult use cannabis industry, and provides compliance training, ERISA plan design consultation, risk management, and employment law guidance. He received his JD from Suffolk University Law School, graduating with distinction with an elective concentration in labor and employment law.
As always, thanks for that warm intro, and it's a pleasure to be here. And thanks to our audience for being in attendance. So the topics that I'll be covering today are some issues related to what Jeffrey referred to as the Great Migration to telework for a lot of employees and the PPP loan forgiveness program. So from my perspective, one of the most important new developments in 2022 for many employers across many different industries and verticals was the commencement of the Paycheck Protection Program loan forgiveness program, which has necessitated this whole cottage industry of accounting specialists and CPAs and attorneys to determine how variances in headcounts and net wage outflows contribute to the forgiveness of PPP loans. And there are many aspects to how PPP loan forgiveness is determined and how it's calculated. I'm happy to answer your questions about that in the Q&A, but just in brief, these processes look mainly at what your net headcount was at the time that you submitted for your PPP loan back in 2019, 2020, what your net headcount was at the time that you submit for forgiveness. And then there's also a formula that goes into that about what the net difference in your employment-related expenses has been over that time, sort of a back of the envelope for how much of the PPP loan did you actually use on employment-related expenses, which, as for those of you in the audience who are employment law professionals or HR professionals, know that means quite a bit more than just wages, right? Some of the items that Jeffrey touched on, items like software subscriptions, home office setups, even things like peripheral benefits and that kind of thing can count towards those calculations. But we want to save a lot of time for the Q&A session. So I'm going to move on to my next big topic here, which is the general trend that we're seeing in employment law, particularly from the plaintiffs bar, about how state, county, municipal governments, and private employers have adopted new and revised compensation plans and work schedules and that sort of thing to account for the great migration to remote work, which many workers are returning to the office, but many of them aren't. And so while the fundamental laws that fundamentally underlie how remote work is tracked from a wage and hour perspective and what is compensable didn't really change. They really have sort of bubbled up to the forefront of compliance and risk management and litigation because some of these issues that were once fairly obscure, like when is somebody who is at home but checking email on their phone working, that kind of issue has become much more routine these days. And it's really important that you or your clients be prepared for this to be a potentially permanent setup for a lot of your workforces. And meanwhile, there are these adjustments to your standard employment document stacks, from your employment agreements to your handbooks, to cover remote work time, that have really gone from, again, the very obscure to the very standard.
Yes, and thank you for that overview, Christopher. And last but certainly not least, we have attorney Jessica Youngs, who will deliver guidance on new state-level paid time off laws. Jessica Youngs, the founding and principal attorney of Octans Legal, is an international attorney with over 15 years of experience in law. Jessica's practice focuses on general counsel services for small and mid-sized software, technology, and commercial clients, and includes employment law, corporate data protection, and risk management consultations. She is barred in the states of New York, Illinois, Georgia, and the District of Columbia.
Thank you so much for that introduction, Leon, and I'll echo what our other panelists said about very happily speaking with all of you today, and thank you for taking the time. So today I am going to be speaking with you about PTO, or paid time off, as well as FMLA, or family and medical leave. In terms of the big picture as to what's happened in 2022, what we're seeing is that many states are looking to codify some of those emergency PTO or FMLA regulations that came into effect during the COVID pandemic. So most of those changes were put in sort of emergency regulations, although some of them were done already through direct changes to the statutes that relate to PTO and FMLA in various different states. What we have now is a continuation of that trend looking at expanding PTO, looking at expanding FMLA leave on some important topics such as such as mental health issues, or also to care for a sibling and some other things that we'll get into. So as I mentioned, many of the COVID-19 emergency laws that were enacted on a temporary basis. Most of those have gone ahead and been extinguished by this point. And so what states are seeking to do is to get those either permanently or enacted, or to modify them in a way that does continue to allow them to function or continue to allow them to come up again were there to be more pandemics or similar things of that sort. So while that happens, there may be a brief period of about a year or two while states get caught up in codifying some of these, but you certainly should expect that if your state enacted an emergency regulation, to look for enacting a similar sort of thing that can continue in permanence. And the result of that has been that now we have quite a wide range of PTO and FMLA leaves that vary widely by state to state. So for employers who have employees located in multiple jurisdictions, and this is especially true when we consider employers who may have employees who are now working remotely or who are working from a jurisdiction where they were not originally hired from, you really need to take extra care to bring yourself up to date on what the new PTO or FMLA leave laws are for those jurisdictions, or maybe that are coming into play next year or in the next few years. And this is really true regardless of what the choice of law that may be set out in your employment contract or your offer letter may be. I have seen quite a few clients have their employees try to litigate that or make claims based on a different jurisdiction. So it is something to watch for. So currently 11 states plus the District of Columbia provide for paid FMLA leave. Now, new additions to that list in 2022 included, for example, Connecticut, who has a new expansive paid FMLA leave program that gives 12 weeks of benefits for nearly all private sector workers. So on the federal level, of course, we're only looking at it for employers who have 50 or more workers. In Connecticut, now it's almost all private employers. Self-employed persons in Connecticut also have the ability to opt into benefits. And that's just one example of how states are seeking to change these laws, and will change them in the future. In addition to PTO for FMLA leave reasons, 16 states as of this year are now requiring paid sick leave in the private sector, with the majority of states really doing that as a continuation of the existing bills, or of the existing emergency regulations that were enacted. On the family front, we now have 3 states that are giving paternity leave for state employees, as well as adoption and birth leave, and also fostering leave. Some states as well, starting this year, for example, South Carolina, are also now additionally providing paid leave for military family visits. So that's something new and something we probably will see in more states in the future. Several states are also providing PTO for school-related events. So if you have employees who have school-age children, do take note of this. In California, the employees are eligible for 40 paid hours to attend school-related events. Let's say that's a parent-teacher conference or a sporting event for their children. In Illinois, that amount is 8 hours. So as you can see, that does vary really widely state to state. And these are just 2 examples. There are quite a few other states that now are providing this child activity school-related event PTO leave as well. In 2023, we do have obviously some new laws coming up. I'm not going to talk about many of them in depth, but one that is, I think, notable is what's happening in New York, and that includes FMLA leave that's paid for caring for a disabled sibling. Typically, we've seen FMLA leave be limited to caring for a spouse or a child, but we are seeing it, for example, in New York, being expanded to other types of familiar relationships.
All right, thanks so much, Jessica. Before we begin, Personnel Concepts is offering all of our attendees our independent contractor classification checklist, along with today's slide presentation equipped for note-taking, all of which are attached as handouts right here in GoToWebinar. At the end of the session, you'll receive an emailed certificate as proof of your attendance today. To participate in today's Q&A session, I want to encourage everyone in attendance to submit questions by using that Ask Question feature in GoToWebinar. You can also contact our webinar staff by using the chat window. If you'd like to pose your questions directly to our guest speaker using computer or telephone audio, just use that raise hand feature in GoToWebinar, and we'll coordinate with you on your request. We'll do our best to get through the most relevant audience questions throughout today's session, and all unanswered questions will be submitted to our attorney panel for responses and sent to you via email. So don't worry, they will get answered one way or another. So with that, we need your help with one more poll question before we get started with the Q&A. Leon?
Yes, and as you've heard, our panel of experts are prepared to answer your questions on various wage and hour law changes in 2022 and beyond. So what we would like to know from you all is, outside of the selected topics, what wage and hour law topics might you need addressed in today's Q&A session? And the reason why we ask is because we want to somewhat prepare our panel for any questions that you will continue to submit. So please actually submit those in the chat window, as we are going to get started in just a second. So is it state or city minimum wages that you have questions about? Industry specific wage and hour requirements, inflation and the consumer price index, FMLA or mental health issues, FMLA for mental health issues, that makes it a wage and hour issue. And then, or is it some other topic that is a wage and hour related? And please, as you respond to the poll, go ahead and submit that question based on the topic that you feel like you need assistance with. I still see things coming in. I'll give you just another moment here. And it looks like we're kind of all over the place. People want to know about industry-specific wage and hour requirements. FMLA for mental health issues, quite a bit, hitting at 41%. And of course, state or city minimum wages, that's always important. And also inflation and consumer price index. So a little bit all over the place. Please submit the corresponding questions. That way we can try and get to them throughout this Q&A session.
Yeah, thanks for participating in the poll. We'll also be putting the question up on the board, so if at any time you forget the topic, it will be right there for you. So with that, we'll go ahead and get started and put our first question on the board, and I'll do my best to direct it here. If any of our guest panelists feel like they want to chime in on somebody else's question, feel free. So our first question here is, do you have any tips for success in the PPP loan forgiveness program? Do we need to know if any changes in this particular labor law referring to wage and hour? I think I'm going to direct this one to Christopher.
Sure, I'll jump in on this one. So, you know, the place to begin with the PPP loan forgiveness program is always going to be your attorney, your tax counsel, and your CPA. Part of that workflow definitely should include your VP of HR or your HR director, whoever's been responsible for your payroll over the last several years, because as I mentioned in my segment, the formulas for determining how much of your loan is forgivable and the various certifications and evidences that you need to provide in order to get that loan forgiven, they really start with these two big pieces: your net full-time employee headcount and your net employment-related cost outflows, mainly wage, but also wage-associated costs, things that likely would have gone through your HR department, everything from home office setups, equipment for employees, trainings such as this one are likely eligible for inclusion in that cost. But you know, you should be having, you know, your usual slate of professionals on your side for this. But something else that we've seen in the industry, because the decision was made at the time that the loan program was instituted, that most of these loans did not come directly from the government. Rather, they flowed through private lenders who served as administrators, and the government essentially guaranteed these loans. And so we've seen a lot of private providers who actually have put out some very solid guidance about how to go through this program. So for example, if you use a major banking source like Bank of America, Wells Fargo, these, some of these larger banks have even created these specialized software tools or back-end portals on your business banking online services that will give you, fillable boxes and guidance documents that you can use to apply for your PPP loan forgiveness. So, your first phone call may actually be to your bank manager or whoever is managing your revolving line of credit, or any of these private sources who may have also served as your loan, the disbursement source for your PPP loan. But at bottom line, you want to start with your HR professional, your CPA, your tax counsel, and your general counsel for any of these PPP related issues.
Okay, thanks so much, Christopher. All right, let's get the next question on the board here so we can get through as many as possible. Under the recently updated FMLA guidance for mental health condition, what qualifies as a, quote, serious mental health condition in order for an employee to qualify for leave? Jessica, I'm going to direct this one towards you.
My pleasure. So the Department of Labor actually just issued quite a recent fact sheet in May of this year regarding mental health and how that is covered by the FMLA. Now, to be clear, of course, mental health issues were always covered by the FMLA, but this makes it more clear as to what really would constitute a serious mental health issue. And what we have here is that there are sort of two ways that the Department of Labor has come up and said this will be covered by the FMLA. So one of those is if a condition has required inpatient care that includes an overnight stay. So that could be, for example, at a treatment facility for addiction, eating disorders, alcoholism, what have you. But one avenue towards that is an overnight stay at an inpatient care facility. The other avenue is sort of bifurcated, and it is a serious mental health condition that requires continuous care. Continuous care can look like one of two things. It can look like conditions that would cause an individual to be really severely incapacitated, unable to do their work for 3 consecutive days, plus on top of that, that they would require ongoing medical treatment. So for example, ongoing medical treatment being an appointment with a psychiatrist or a psychologist, social worker, something like that. It also includes follow-up care, being a prescription medication or outpatient counseling, CBT, something along those lines. So we have, again, we have the continuing treatment. One avenue is incapacitating someone for 3 or more consecutive days, plus ongoing medical treatment. The other avenue for this continuing treatment aspect of a serious mental health condition to be covered by the FMLA is a chronic condition. So a chronic condition, really the most prevalent among American employees, is anxiety, but it also could be things like depression, or the Department of Labor guidance mentions dissociative disorders. And that sort of chronic condition needs to require that the employee is, again, incapacitated, unable to perform any job duties that would also require treatment by a mental health provider at least twice a year. So they need to be unable to perform work twice a year. That's going to meet the level for chronic condition. So those are the different ways that a serious mental health issue has been more narrowly defined by the Department of Labor to be covered by the FMLA. If you've not checked out that fact sheet, it's fact sheet 280, and I would take a look at that, as it provides some good examples for employers. It provides sort of the documentation that you request, all of those good things.
Okay, thanks so much, Jessica. All right, the next question on the board here, keep it moving. If an employee is an admin or associate position is making above $58K per year, are they still considered an hourly wage employee regardless of salary? I think I'll direct this towards Jeff here.
Thanks, Stephanie, and thanks to the member of our audience who asked that question. That's a great question. And traditionally speaking, the amount of the salary was often in a lot of fields tied to positioning. So there became sort of this general mentality that if a person made above a certain number, that would be an indicator that they were an employee instead of an independent contractor. Although that line of thinking is eroding somewhat because the test under the current administration and under the DOL is much more subjective and based upon the actual nature of the relationship. As Jessica and Christopher and I have all talked about today, the post-COVID-19 work situation has really kind of shuffled the deck as far as this goes. And so salary enough is not a qualifier anymore standing alone to make a determination about whether somebody's an employee or an independent contractor. It may be a fact that leads towards the analysis, but the analysis has to involve the nature of the actual relationship. What does this person who's the individual working for the business, so the person that's the employee, because they're not necessarily an employee, so I don't want to throw that word around, but what is this individual who's working for the business? What are they doing? Are they working under a contract with very specific terms? Are they working for other people? Is their work dispersed? Are they doing it under an LLC as opposed to themselves as an individual? What's the benefit situation? What is the control of the work that they do? Do other people provide the same services at the same time? There's a lot that goes into it, and there's numerous resources available, including the test that Personal Concepts mentioned today, that they have the sheet that you can use to look at some of this stuff. But it is a fact-specific analysis, and the salary of 58K or above, or any number above, that's just one fact now at this point. I do want to point out the other aspect of this question, since it's up on the board and everybody can see it. The admin associate position part of the question. There are several classifications of workers who do fall under what are considered to be the non-exempt workers under the FLSA, and those are the executives one, I think administrative is another. There's about 5 or 6 classifications, and one of those does tip off with the word admin, so you may see that on there. But again, it still remains a fact-specific analysis. You really need to look at the job description, what you're actually, relying upon the individual to do for the company, and what the relationship is between the employer and the employee, because that's what the courts are going to do if it goes that far. So you're better off doing it in-house and understanding it. And you have a lot of control there as the employer, because you're setting up the job and you're setting up the relationship. They're coming to you. So you can, look at those factors and try to decide, would you rather have independent contractors or would you rather have employees? Thank you for that. Listen to all that.
Thanks, Jeff. Thanks for that guidance there. All right, our next question here on the board. Are there any advantages to hiring permanent workers versus contract workers? We're well aware of the fiscal advantages of hiring contract workers, but we're considering hire workers for our long-term projects. Jeff, I see you wanted to raise your hand there. Yeah, you can jump in.
Nobody else minds. It really does kind of dovetail into the question I just answered. Yeah. While everybody's used to the sound of my voice, it's just to be kind of follow up on it. That is also a fact-specific analysis. There is not one answer for the employer. There's a whole bunch of considerations as to what you might want, but here's some of the ones that you might want to consider. You talk about it as a lot of employers look at it as a cost savings to have to have contract workers versus long-term workers. That may or may not be true depending on what your business is trying to do. The traditional thing that everybody thinks of usually with most of my clients and most of the people out there that have businesses of different sizes is, oh, we don't have to pay their benefits, we don't have to pay their insurance, we don't have to pay their 401k if that's something that's still being offered. Those are all things we save money on. That may be true, but you also may lose control over the worker. The old punch in, punch out mentality, give very specific tasks, expect somebody to be present for your calls, especially in the remote environment where people are home. Hiring somebody as permanent often gives you more control over them because we go back into this situation about dependence upon the employer. If you're an employer and they're an employee, they're going to be more engaged in the work they're providing for you, and so that relationship is going to be stronger, and that's going to give you more control. So for long-term projects, that may be something you want to have, is more control over the employee, not have them working for many different employers at the same time. The other aspect with that is competition. If you have an independent contractor working under a contract as opposed to an employee, you have to be very specific about what they can't do, perhaps, that could be competitive with your business. Remember, they're gaining skills and knowledge and various things, confidential information, inventions, all those types of things that are happening with your business And they're going to want to, if they're an independent contractor, they're going to want the freedom to work for other places, and that could be detrimental to your operations. You have to then contract very carefully and keep an eye on those things, and that could be problematic too. Something that you might not have to worry about as much if you're providing sort of the day-to-day bread and butter, the needs of the employee. They may not work as much for other entities. So there's a lot to think about, but those are just some of the overview type considerations. It may not be more cheap in the long run. It may just appear to be on the surface. You have to think about what you'd like out of the relationship.
I would just add to what Jeffrey just said in his excellent answer that I would refer back to something that you said, Jeffrey, in part of your presentation when you talk about the test for employees and independent contractors. Is, I've litigated some of these misclassification cases, and I would just want to really drive home the point that it is not entirely up to you as the employer whether or not somebody is an employee or an independent contractor. You should look at it more as it is up to you to recognize which relationship best describes the relationship that your company has with a given person. So, if you have somebody who's in the office 8 hours a day and, you provide all of their equipment, they're under a non-compete and an NDA, they use the leads that you give them to make sales or do whatever their work is, and their badge says, I work for company so-and-so. It's not in your power to simply say, well, this person is an independent contractor, just because there may be some cost savings associated with that. That is a relationship that, because it likely describes somebody who should be an employee, that person should be on your W-2, getting your payroll, having taxes withheld. And one last point I would drive home on that, and that I'm sure Jeff has seen in his own practice, is that litigation over these matters can be really expensive for employers. There are these sort of hidden costs built into misclassification that in some jurisdictions, like where I practice in Massachusetts, you see multiple damages. You see damages that are related to taxes that should have been withheld and paid, damages related to health insurance that should have been provided and wasn't. So I would just make really clear that you're using the resources that are provided by groups like Personnel Concepts. You're talking to attorneys like Jeffrey, making sure that you're really you have the proper eye and are properly classifying your employees and not simply deciding that a person is an employee or an independent contractor.
And to Christopher's point, just to add one more thing to the damages, these damages called punitive damages, you wouldn't ordinarily see those in a contract case, but in the situation where you bring in the FLSA and some of these other larger laws that have civil rights undercurrents, things that are there for other reasons, it could really spiral out of hand. So when you talk about the expenses associated with misclassification, you've got to think about even damages that are corrective in some places under state or federal law to try to set you straight, and also the exposure of the company, because the fact-specific analysis that a court's going to have to go through to figure that out, if you can't figure it out by using the resources you have on the front end, that's going to be a lot of information, a lot of paper out there about how your company runs, what they do, how the people work for them, and that can really be exposing in a way that employers don't want to have to deal with that. So try to think about what you can do up front.
Yeah, thank you both for your insight on that. All right, let's see if we get another question on the board here. Is forced PTO subsidized by state and federal governments? We're happy to offer required paid time off, but are worried about the financial implications of doing so. Jessica, do you want to take this one?
Sure. So I think that this can come down to a few different things. First of all, maybe saying, is it subsidized is the wrong way of hedging it, because it's not going to be subsidized. However, there are ways that employers can be benefited or benefits that they can receive by giving PTO. So for example, during the pandemic, we saw that there were various tax credits that were given to employers whose employees were taking PTO or FMLA leave or some of these emergency leaves, right? We had the American Rescue Plan Act of 2021 that's already phased out, but that did provide some additional tax credits for employers. We also had the COVID-19 Tax Relief Act of 2020, which provided tax credits and tax benefits for employers. And we do have, although those are already more or less phased out. There may be some in some jurisdictions in a few states, but on the federal level, those have gone by the wayside at this point. However, there are in the IRS code actual tax credits that are provided for paid FMLA leave. So the IRS code section 455, I believe it is, does provide tax credits for employers who provide this type of leave. And there's different types of tax credits that are available. Now, in terms of what may be available on the state-wide level, it's important to remember that a lot of these benefits are actually paid for not directly by the employer in a sense, but both by the employee and the employer as part of what is taken out of the paycheck, what's taken out of the wages. So they are already paid in through the payment of premiums, right? So it's not as though employers necessarily are directly having to pay these. In a lot of states, California, Washington being a good example, there are ways that employers can claim back this through sort of an insurance program or through a state benefits program. So there are in many jurisdictions options available to employers. I cannot promise that that's true in every jurisdiction, but it certainly is worth it to look at in your jurisdiction to see if in fact FMLA leave or some types of PTO can actually be taken from one of these programs that's administered by the state that may be administered by your insurance.
Great, thanks, Jessica. Great for our audience to look into. Okay, next question on the board here. Do we have to pay overtime to salaried employees who do not clock in and out? Can you speak to general overtime requirements for employers? Overtime here. Jeffrey, did you want to jump in on that one?
Yes, I am happy to, Stephanie. We talked a little bit earlier about the general looking at the employment relationship and how, as Christopher said, you can't just make a determination. You have to understand that you really have to look at the facts of it. You know, the very nature of the work being performed, and especially the nature of the relationship, perhaps to some extent the dependence of the worker on the employer. The clocking in and clocking out aspect is similar to that. We know now that people can clock in and clock out in a variety of ways, whether they be on handheld devices or computers, or I think it's pretty much gone now, but the Fred Flintstone time clock that you go in, you know, yabba dabba do on Friday, and you push the paper in. I think that's pretty much gone probably for most places, but that is just a consideration. Clocking in and clocking out has very little to do with the actual counting of the hours. And the counting of the hours is such that if you are a employee who is protected by FLSA, then if the hours exceed 40 hours in a given work week, then generally speaking, you're entitled to what sometimes is called time and a half for the hours that are over 40. In other presentations that we've done for personal concepts, we had a question once that talked about what happens if my work week doesn't go Sunday to Sunday. That may seem like an easy question, but there's lots of employers out there whose work week doesn't go Sunday to Sunday. The FLSA looks at the 7-day period based on how you constitute a work week. So whether it's Sunday to Sunday, Monday to Monday, Saturday to Saturday, whatever the case is, Wednesday to Wednesday, it could be anything. But that 7-day period that's used for the purposes of doing your payroll is what's used for the purposes of looking for the 40 hours. So if you're protected by the FLSA, it doesn't matter how you punch in and out. It doesn't really matter at all, except for how much you actually work and whether you fit into one of the categories of exempt or non-exempt workers and would be subject to the protections of the FLSA. So again, that's just a small fact. Whether you punch in or out, but again, it's the overall situation. And in the case of overtime, it's related to whether you exceed the 40 hours or not in the 7-day period.
If I can make one mention here as well that's sort of related, I have, since the pandemic started and many employees are working remotely, I've had many clients who have asked about sort of these timekeeper sort of applications to check when employees are coming in or out or if they're actually doing the work. And those can vary from things such as screen recordings to keystroke recordings, logs to mouse click logs, to all different kinds of things. If that is something that you have been using or you are considering to use to see if your employee is doing overtime or actually doing work during the time that they're clocked in or clocked out, I would suggest that you also very strongly take a look at what the if they're classified correctly as an employee or a contractor, and also what the data laws may be as to, in your jurisdiction, as to whether these types of things are possible or not possible. There have been quite a few cases that have come up that have been litigated on these issues, and I'm seeing more and more and more requests come into from employers about, can we use this? How can we monitor our employees to see if they're doing overtime, or if they're actually clocking in, clocking out? Are they working when they're saying they should be working? And that's especially for remote work employees.
Excellent point to add. Thanks so much, Jessica. I'm sure somebody definitely had questions about that one too. All right, let's see if we can on the board here. Let's see, have there been any updates pertaining to FMLA or maternity, paternity leave? Also, if you can speak to any leave, wage and hour laws that are specific to Pennsylvania. Anyone familiar with that area specifically, or want to answer the general question?
Yeah, so I think that that is for me, since I was talking about FMLA. Now, in terms of Pennsylvania, I cannot speak directly to Pennsylvania. I'm not licensed there. I don't do any work in Pennsylvania, and I don't think that any of the other panelists are licensed there either, but if they are, please feel free to jump in. There, as far as I know, actually have not been any changes to maternity or paternity leave that are substantial in any nature. What we do have is on a state level, there have been some changes. So I mentioned one state in particular that is now allowing paternity leave for some additional types of issues. So not straight after the child is born types of things, but also if there's an adoption or a fostering situation. So we are seeing states become a little bit more progressive, a little bit more expansive on that. At some point it may change, but that's all that I really have to say on that. And again, I can't speak specifically to Pennsylvania, but maybe one of our other panelists can.
Great, thanks, Jessica. Yeah, I noticed it wasn't anywhere where you guys where you're currently barred. So well, let's see if that was a good general answer to that portion of the question. So if we could move on to the next question on the board here. If you have any other specifics or wanted to ask something else, you could also put it in the chat. And if they don't get to it now, we will get to it later via email. Are commission payments factored into salary calculations for non-exempt employee status?
And before we jump in and answer that, we'll actually give our panelists just a minute to ponder on that. This will likely be the last question. I did want to include that state-specific question just because it was part of the entirety of the question that they asked. But we have been getting a number of specific questions as far as campus police worker. I believe someone that worked at a it looks like some type of church where they double duty and are a choir director, and there may be some overtime there. So just a reminder to everyone that we will be answering those more specific questions via email afterwards. And then another question came up, if there's any supplemental resources for HR to use regularly to keep up to date with legislation changes in employment law. So I just want to remind everyone to utilize Personal Concepts blog. It's Personal Concepts at blog.com or blog.personalconcepts.com, excuse me. And then also we have a wage and hour newsletter that goes out quarterly that you should also pay attention to as well. And you have access to those as subscribers. So like I said, this will likely be our last question, so we can finish up with some final tips. But please, one of our panelists jump in on this question about commission payments.
I would like to jump in on this question, and I almost want to ask if one of my associates is the one who planted this question, because this was the exact question behind my very first plaintiff side wage and hour case. If I understand the question, it's you have an employee where they earn some base hourly rate, but they also do commission sales work. Should that commission be taken into account when calculating somebody's overtime pay? The answer is yes. And this is the case under federal law without reference to state law. So if you have an employee salesperson who gets some base pay rate, hourly rate, and they also make commission sales, how do you factor in their commission sales, which are going to vary from week to week or even hour to hour? How do you factor that into their overtime? There are a couple of different formulas that the Department of Labor has published over the years for how to do this, but you should essentially take it out of the pay period in which the employee is earning the overtime in question. So if for week 1 of 2020, January to January 7th, your employee worked 45 hours, they've got 5 hours of overtime. How do I calculate how much that overtime is worth? Well, it's 5 hours times 1.5 times their base hourly rate, and then you take their commission payment. Say they made $100 worth of commission sales. How do I factor that into their overtime? Well, you take that overtime payment, or sorry, you take that commission payment as a percentage of what the paycheck would have been without overtime, and then you just multiply that percentage by 1.5. So you're taking these two separate items, you're multiplying it by the overtime rate and paying it. But I am very excited to say authoritatively the answer is yes, because I was very pleased back in 2017 to have a judge agree with me on this matter in the Hillsborough County Civil Courts of New Hampshire.
They're definitely the right person to answer that question for us. Thanks so much, Christopher. All right. And unfortunately, we've run out of time here. All unanswered questions will be forwarded to Jeffrey, Christopher, and Jessica via email, and their responses will be sent to attendees in the coming days. Thanks to everyone who submitted questions for today's session, and thanks to our panel for taking the time to answer them.
Yes, that was a very informative session. Thank you all again to our panels and all the questions that were submitted. And speaking to that, we would like to understand how you were able to contribute to today's presentation as far as attendees. So with our final poll here, we're going to ask, how were you able to participate in today's session? We'd like to hear about your level of participation. Did you submit a question and had your question answered? Did you submit a question, didn't receive a response? Hopefully not. You didn't submit a question, but it was already answered for you. Did you not have any late wage and hour law related questions, or were you just attending to hear questions from our attendees?
And as we wait for those poll questions to come through, just a reminder, we do have a key takeaways coming up as well.
Yes, so make sure you stay tuned for that. And to get to that as close as soon as possible, I'm going to go ahead and just share our results here. So most of you guys attended to hear questions from other attendees, which is great because we had tons of questions. I don't think anyone, we had one person said they submitted a question but didn't receive a response. We apologize for that. We'll make sure to get out that answer afterwards via email. So based on the results, it looks like everyone hopefully is happy with their level of participation today. Thank you for everyone who responded. And Jeffrey, can you get us started with the key takeaways on the FLSA and employee exemptions?
My pleasure, Leon. Thank you to our customers today who listened, and also thank you, of course, to Stephanie and Leon for letting us talk here today. It was really a lot of fun and a great opportunity to share information and explore what the questions are out there. Here's the key takeaways for employers to consider in 2022. First off, the nature of the relationship generally determines whether a work relationship is truly an employment relationship or an independent contractor relationship. Meanwhile, DOL's recent proposed rule focuses heavily on the independent contractor's economic independence from the employer. Number two, note that employers are restricted in taking a tip credit when the employee performs a substantial amount of non-tipped work for the employer. That's over 20% of the employee's work. And number three, minimum wage was increased for any workers performing work on federal contracts as of 2022 to $15 an hour, which will affect many businesses that enjoy the great situation of government contracts.
Great, thanks so much, Jeff. Chris, can you remind us about key remote worker and PPP loan forgiveness program takeaways?
Sure, and I'll echo, as always, thanks to the Personnel Concepts team for putting this on and letting us speak. Thanks to the audience for their attendance and for their great questions. So I've assembled a few takeaways from the items that I spoke on today. Number one, most importantly, when you're going to get your application for your PPP loan forgiveness submitted, it's really important to have the full slate of the usual experts, on your side for seeking this forgiveness. You want to involve not just your general counsel and your tax counsel. You want to also make sure that HR is integrally involved in that process, because so much of the forgiveness is keyed to costs and events that would flow through HR anyway. But I would also encourage everybody to seek out the resources that might be available, both from private providers like Personnel Concepts and from your loan originator, which could be your banking resource or whoever supervises your revolving lines of credit. Point number two is that the transition of so many both government and private work functions to temporary or increasingly telework functions makes tracking employee hours and compensation for hourly employees a real prime focus for compliance professionals. As I mentioned, the substantive laws underlying these changes, these issues haven't changed substantially, but the amount of liability that we're seeing growing on these issues, and some of the things that we touched on in the Q&A, like employees checking their phones after hours and that kind of thing, means it's really important to make sure that you go back and make sure that your processes on these matters are all buttoned up, similar to point number three, which is, due to this proliferation of remote work, you're going to want to make sure that your employment agreements, your forms, your handbooks, your sort of standard employee document stacks are all updated to incorporate what may be a greater level of specificity that you need for your employees about when they're working, when they should be working, and when they're not. For many employers, it's no longer as simple as somebody's at work when they're in the office and they're not when they're not, right? Now that people can check their email on their phones at home, where they may be most or all of the time, it's really important to make sure that the advice and the instructions that you're giving to employees are consistent with best practices in this area.
Yes, much appreciated, Chris. And Jessica, please bring us home with the key state paid time off and family and medical leave laws in 2022 and beyond.
My pleasure. And as the other panelists said, thank you very much for attending and for listening to all the things that we have to say. I hope it's been very informative. So in terms of PTO and FMLA, here are the things that I would say are the most important to remember as you finish out this year and look into the next one. First of all is that several states have moved to introduce new PTO laws, or they expanded laws that were in many ways reflective of what happened during the pandemic. Some of those were codification of those emergency measures, others were expansions of those emergency measures. So do take care, especially if you were in a state that had some emergency PTO or FMLA leave that was enacted during the pandemic. For employers who have employees working from multiple states, especially if they're working from home, working remotely, I would recommend as my second thing to remember that you take extra care to become familiar with the leave laws for the jurisdiction in which that employee is actually based. We are seeing a lot of litigation. In fact, I have something tonight that I have to do about those kind of issues, right? Where has the employee now moved to? Where maybe they working from home, that sort of thing. So do take care to become familiar with the PTO, with the FMLA, and with all of the general employment laws in general from that jurisdiction in which the employee may now be located. And lastly, 11 states plus the District of Columbia are now requiring employers to provide for paid FMLA leave. We're seeing that get expanded further and further and further. So do take care, especially if you may be in a jurisdiction that's a little bit more progressive, to look at what is actually coming up in terms of what sort of things your employees may claim for FMLA leave.
Thanks for reviewing that for us. And before we end today's session, I'd like to remind everyone that all attendees will receive a follow-up email with a certificate as proof of attendance to today's webinar. We enjoy hosting webinars for our valued customers, and as such would really appreciate your feedback. Please stick around a couple minutes as a brief survey will open for you to rate what you saw and heard today.
Yes, and this concludes today's webinar. Thank you for attending our presentation. We hope you enjoyed and benefited from today's Ask the Attorneys Wage and Hour Changes and Trends webinar session. Thanks again to Jeffrey, Christopher, and Jessica for participating as our expert panelists. We look forward to continuing to work with them on future presentations. And if you enjoyed today's webinar, we invite you to view past webinars on demand at the link provided on the screen. To all of our attendees, thanks for choosing Personnel Concepts as your provider of workplace compliance solutions, and have a good afternoon, everyone.